One of the big benefits of this workshop is this interacting and networking. When I originally started it, it was so particularly airport attorneys could meet and talk with each other and learn from each other. And I can say after 15 years, I think that's been a success. So appreciate all of you being here, and we will get started. I'd like, Rod can, yeah, thank you. Okay, I'd like to introduce Jim Lofton, who is FAA Assistant Chief Counsel of Airports and Environmental Law. I really appreciate Jim coming all the way from Washington to join us. A few of you may have been in his session at the FAA conference in June, this last June here in Western Pacific region, and I was in that session and immediately made note of what an entertaining speaker and some of his information on cases that he's been involved in. So with that, you can read more about his background again in the bio, but with that, I'll turn it over to Jim. Thank you.
Thank you so much for having me. I'm going to address 4 different topics this morning, but before I do that, I want to follow up on the PFAS discussion a little bit and offer a couple of ideas and comments. The first of all, which is if you are familiar with the Superfund Act, which is the Comprehensive Environmental Response, Compensation, and Liability Act of 1982, if you are liable under that statute, you're strictly liable, which means it's a no-fault statute. If you're in one of 4 categories, you are liable. And the only question is, how much are you going to pay? And one of those 4 categories is owner and operator. So if you're an owner or an operator and that facility is going to undertake a remedial cleanup, then you're going to pay for part of that. So I guess the point that I'm making is that the House has passed a bill, but it hasn't gone to the Senate yet on PFAS legislation, and I truly don't think that the Senate is going to pass it in its current form. But my advice is that if you are thinking you're going to be liable, you want to establish, if you can, you want to lobby for a funding mechanism. And that funding mechanism, as I will talk about, possibly could be airport revenues, but you also want to be able to lobby for funding from either from the state or for the federal government. It makes a lot of sense to me to clean up PFAS contamination, but there also needs to be a funding mechanism. And if Congress is going to address this and pass a comprehensive bill requiring cleanup of PFAS at airports and everywhere else there is contamination, then there needs to be a funding mechanism, whether it's paid for out of a fund that Congress provides or some other way that the funding can materialize. So the 4 topics that I'm going to cover today are, first of all, we have a lot of cases that have been filed against the FAA under the National Environmental Policy Act, and they primarily involve aircraft procedures that have been changed and people unhappy with aircraft noise. And so I'm going to cover some of those cases, and then we're going to move to aviation fuel taxes, which of course is a subtopic under airport revenue diversion or airport funds revenue diversion. And I'm also going to talk about a recent case that involves another aspect of alleged revenue diversion, which is the Port of Portland Stormwater case that was just handed down by the Ninth Circuit this last year. And then finally, I'm going to cover Section 163 of the FAA Reauthorization Act of 2018 and talk about some of the changes in the authority of the FAA to regulate airport property. And so we should have plenty of time for those topics and for some questions as well. So let's go back to the NEPA litigation. The National Environmental Policy Act, of course, is a federal law that is a procedural statute, but it allows people to bring a lawsuit that alleges that when there is a federal action or a federal order, it allows people to challenge whether the government agency, in this case the FAA, has procedurally done the right things and gone through the act, the regulations and the policies that the FAA itself has written on how the environmental assessment and the environmental documentation should have been done. And so when we get sued under the National Environmental Policy Act, we get sued because the petitioners allege that we haven't done these procedures correctly. So back in 2017, the city of Phoenix and several neighborhood groups west of Phoenix Sky Harbor Airport sued the FAA under NEPA, the National Environmental Policy Act, also the Historic Preservation Act and Section 4F of the Transportation Act, alleging that the FAA had violated these environmental statutes in implementing RNAV routes, changing Western departures at the Phoenix airport. And much to our surprise, the petitioners prevailed in that lawsuit despite the fact that they had missed the deadline for filing a lawsuit against the FAA under these statutes. There's actually a 60-day deadline for filing lawsuits under the statute that has jurisdiction over the FAA. It's 49 U.S.C. Section 46110A. So that case, though, was the first in a line of cases in which this was a reported decision, came out of the D.C. Circuit, and the Phoenix case was the spark that ignited a conflagration of cases against the FAA. We now have all these cases across the country in which different neighborhood groups, communities, states, counties, and even individuals have alleged that the FAA violated the National Environmental Policy Act in implementing its procedures or procedure changes that were made at various airports across the country. 4 of these cases, as you see on the East Coast, involved the D.C. Metroplex. The cases on the West Coast, the 3 that you see together there, involve the Southern California Metroplex, and we had one case that involved the Northern California Metroplex. So I'm not going to talk about each and every one of these cases. After all, what they are really about is people being unhappy with aircraft flight procedure changes where all of a sudden aircraft are over my house rather than someone else's house. And typically what the petitioners want is they want the routes changed back to where they were before the FAA made the procedure changes. And of course it's a zero-sum game. If we change the routes back, someone else is going to have the noise that the petitioners are unhappy with. Now, certainly there are times when we can change routes and we can put them over either less populated areas or areas that are not populated, for example, the ocean, and we do that where we can. But route changes, as you may know, if we're doing an RNAV route, it's being done primarily for safety and reliability purposes, and there are many instances where if we've changed a route, the old routes are gone. They're no longer in place. The air traffic controllers have been trained to implement the new routes. They no longer are trained on the old routes, so it's very, very difficult for us to go back and change the routes. So as I said, I'm not going to talk about each one of these cases, but I'm going to talk about a few of the cases, and I'm going to talk about the Phoenix case to kind of give you a flavor of what the issues were in that case and what we've done to learn from the lessons, primarily from the Phoenix case. So in August of 2017, the D.C. Circuit granted the City of Phoenix's petition for review and vacated a number of Western departure procedures that the FAA had implemented in September of 2014 at the Phoenix Airport. So you can see from this slide the RNAV routes in the blue that were implemented after 2017, and then the RNAV routes that were implemented after the settlement agreement that we came to with the City of Phoenix after we lost that case. And so basically what you're seeing there is that the blue routes were the RNAV routes that were put into place that were challenged, and the purple routes were the routes that were put back into place, which are fairly similar to the routes that were in place before the RNAV routes were put in place. So essentially, the FAA was forced to go back and redesign and re-implement the old routes, although we were able to put them in as RNAV routes, the GPS-based routes. And so it was kind of a win-win for everybody. The city and the neighborhood groups got what they wanted, and the FAA was able to put RNAV routes in at the Phoenix Sky Harbor Airport. There were at least 5 different lessons learned from the litigation in the Phoenix case, and my office actually went around the country to the FAA service centers to talk to the different service centers that implement these the satellite-based changes to make sure that we didn't repeat the mistakes that we'd made in the Phoenix case. And as I mentioned, in the Phoenix case, the petitioners filed late. They missed the 60-day deadline. And what the court said was basically that we continued to talk with the city and the other petitioners, and we gave them the impression that we were going to work with them and we were going to basically cure the problems that they were complaining about without having to litigate. And so the court said because they had the impression that we were going to continue to talk and they didn't need to sue us to get what they wanted, then they allowed a pass for the 60-day deadline. So we've been very careful since the FAA case to reach out to the FAA offices across the country to tell them, be very careful what you say to the public when you're talking to them when complaints are made. And so we've actually been careful to talk to our offices across the country and say, if you are talking to someone about a procedure, make sure you say that old procedure is closed. Anything that we do in the future is going to be a new procedure. It's going to be a new order. It's going to be a new federal action if we do take action, something completely different. The second lesson learned from the Phoenix case is that the court suggested that public opposition and reportable noise increases determine when a project is highly controversial under NEPA. And that's important because we issued a categorical exclusion or a categorical exemption for the procedures that we put in place at the Phoenix Airport, and that was one of the things that the petitioners challenged. They basically said we needed to do the next step up, which is an environmental assessment. And so one of the things that we did was in our FA order, the FA order in place at the time was FA Order 1051E, and that order has now been updated. It's the 1051F, and we have clarified in the FA order that mere opposition is not sufficient for a proposed action or its impacts to be considered highly controversial on environmental grounds, which means that we can do a Cat X even though there is public opposition, and that doesn't amount to extraordinary circumstances or a highly controversial endeavor or a complaint on environmental grounds. And so we have actually changed the implementing order that governs environmental documentation in environmental cases for the FAA to clarify that a Cat X is sufficient, even though there may be public opposition. Third, we are trying to be very careful, and this is where your group comes in, to invite local governments and to provide public notice throughout the consultation process. One of the things that we have to do if there are historic properties or if there are tribal properties, we have to be careful to do consultation. The National Historic Preservation Act and Section 4F of the Transportation Act have a consultation requirement in them if there are historic recreation properties, park properties, or tribal properties. And so we have been careful to invite local governments and provide the public notice that the acts have required, and also to consult with state and local officials when assessing the impacts under Section 4F of the Transportation Act. Basically, those go hand in hand, and so we've been careful on our consultation to actually reach out. The court suggested in the Phoenix case that it was the agency's burden to identify who the right people were in order to do those consultations. One of the things that both the city and the court criticized us for is that we only consulted with, as the court said, low-level Phoenix employees in the consultation process, and the court basically said that wasn't enough. And so one of the things that we're doing now is when we reach out is that we're asking for the sponsors and the local governments and the state agencies and the state historic preservation officers to identify to us who the proper people are and get documentation so that we are consulting with the right people. And then finally, we are engaging with the key stakeholders and actually getting support from the sponsors, from the localities, and from the airlines prior to making some of these either PBN or RNAV Metroplex changes before we go full bore and make those changes. So we're trying to be very transparent in reaching out to all of the stakeholders who may have an interest and who may have a complaint if they don't think that we've either gone through the process correctly or if they have a problem with where these new routes are being placed. So, as I said, we've been pretty careful, and to go back to this slide, we've actually been pretty successful so far in the lawsuits that we have gotten decisions are so far. Many of these cases have been litigated. Many of them we've gotten decisions on. The only one so far where we got a partial loss is the Burien case. And that decision was just handed down a couple of months ago. So I do want to talk about the Burien case because I think it's something that your group might be interested in because it may affect you when you are doing airport projects at somewhere like the Monterey Airport, which I talked to Chris yesterday about. So the City of Burien case started when the FAA TRACON and the Air Traffic Control Tower did a letter of agreement and and basically formalized something that they'd been doing for a while, which was to change the routes of the turboprop aircraft and put them into a 240-degree turn, and it turns out over the city of Burien, which is just northwest of the airport. So this was the turboprop turns before the letter of agreement, and these were the turns after the letter of agreement. So I'll flash it back so you can see that the turns were further north, and as soon as the FAA made these changes, we instantly got multiple complaints from the city of Burien about aircraft noise. And the city sued us. They filed a petition for review in the Ninth Circuit and alleged that we had not gone through the environmental process, and whoops, we hadn't. We hadn't documented the categorical exemption for these turns, and so we withdrew. We actually withdrew the letter of agreement and went back and did the environmental process, the categorical exemption. And then we reissued the letter of agreement after we did the environmental process and actually issued a 128-page categorical exemption, because we knew that as soon as we issued the letter of agreement again, Burien was going to sue us again, which they did. And so basically what we were doing here is that, as you probably know, Seattle, the SeaTac Airport is a very busy airport. There are beginning to be some delays there, and some of these delays are attributable to the fact that the turboprop aircraft, which are slower than the jet aircraft, aren't getting out of the way. And so these turns were designed to get the turboprop aircraft out of the way sooner and let the jet traffic go behind them sooner and keep air traffic moving. And so we did reissue the categorical exclusion, and this categorical exclusion was for modifications to currently approved procedures conducted below 3,000 feet that don't significantly increase noise over noise-sensitive areas. Well, these turboprop procedures comprised only about 2% of the total flights out of SeaTac. Very, very low number of turns. But as I said, we got sued anyway. And we argued that there were no extraordinary circumstances. And as I said, we issued this 128-page documented CAT-X. And if any of you are familiar with CAT-X's, they can be very, very abbreviated. 10% of a categorical exclusion can be much, much shorter than 128 pages. So knowing that we were going to get sued, we tried to bomb-proof it, still didn't prevent the city of Burien from suing us. And last November, the Ninth Circuit issued an unpublished decision granting and remanding in part the case back to the FAA with instructions to consider the potential cumulative impacts of all the relevant reasonable future actions. And the criticism that the court had was that the Port of Seattle had a master plan, a sustainable airport master plan that was a number of years in the future, but the FAA knew about that and hadn't included it in the environmental documentation. And the court criticized the FAA for doing that, for not including the SAMP, the Sustainable Airport Master Plan, even though, as the dissent said, it was just a plan to make a plan. And so we were instructed to go back and to consider what are called the cumulative impacts of foreseeable future environmental consequences, future actions on the airport, which we've now done. It was not a big lift for us, and so we went back and did that and complied with the remand instructions rather than challenging the decision. So the lesson learned for you is that even though this was an unpublished decision, I'm sure that we're going to see more challenges where the petitioners, and the petitioners are usually people that are unhappy with changes like Burien because aircraft are now going over their houses rather than someplace else. There are going to be more challenges and allegations that we failed to take something into account in our cumulative impact analysis. So the cumulative impact analysis is basically you've got to consider everything that may impact on this future action. And I do think that this opens up a door, a crack of a door, even though it's an unpublished decision. There are a number of law firms out there that make their living suing the FAA for these kinds of actions, and it's obvious that the lawyers out there know about these and how to file these actions. And so clearly we're going to be seeing more of these cases where there are allegations that we didn't consider everything that we should have considered. And I'm going to quote Judge Ikuda, who said in the first line of her dissent, she quoted a band that I actually have never heard of before reading her dissent. Anybody heard of Five Finger Death Punch? The quote is, "It's never enough. No, it's never enough, no matter what I say." That was the first line of the dissent, and of course, we thought the dissent was quite well written and funny to boot. So, how is this going to impact you? Well, let's now talk about a couple of cases where the sponsors were involved, and the FAA got sued, but it really wasn't the FAA that is primarily the person at interest here. And the first one I'm going to start with is the Howard County case, the Howard County, Maryland case that's been filed in the Fourth Circuit. So this case actually doesn't involve directly a noise case. It doesn't involve an aircraft procedure change. This involves a facility that's being built at the BWI airport. We can now say it's an Amazon facility. We weren't allowed to say it was an Amazon facility for many months when we were doing the environmental assessment. But this is a case where, because the capacity of the airport is going to be larger, the allegation is there are going to be more cargo aircraft flying to this airport, and there's going to be more noise. Well, Howard County, Maryland is just west of the airport, and of course one of the routes that Howard County is unhappy with is the RNAV route that flies directly over Howard County. So basically this facility was mapped out about 10 years before we actually did the environmental assessment. The Maryland Aviation Administration, which is actually a state agency, owns this airport, BWI. And they did an environmental assessment, I believe it was as far back as 1998, and they asked us to basically do a reevaluation of the environmental assessment for this 2,000 square foot cargo facility that is dedicated for Amazon. It includes buildings, pavement, parking, taxiway, and takes up more than 30 acres. So the MAA asked the FAA to approve a written reevaluation, which was actually prepared by the Maryland Aviation Administration. And in talking to Chris yesterday, I know that Chris is involved in a pretty big project at the Monterey Airport involving moving the terminal, and that project may involve a capacity increase in order to allow future growth at the airport, kind of like this airport. This is on a much larger scale, but the allegation here is one I think that you should be aware of, because anytime you do a project that increases capacity and you have got people around you that are sensitive to noise, there is an opportunity for filing this kind of lawsuit. So basically, what we did was we took a very well done, thorough technical document that the Maryland Aviation Authority had done, and we worked with that, and we worked in collaboration with the sponsor to develop this written reevaluation, which is basically an environmental assessment. And the environmental assessment, of course, is the middle of the three different types of environmental documentation that you do in a NEPA, when you have to do a NEPA evaluation. The CAT-X, the categorical exclusion, is the shorter version, and then the environmental assessment is the middle ground. And then sometimes, not very often, but sometimes you have to do an environmental impact statement, which is very long, very involved, very costly, and takes a lot of time to do. And so this one was the middle ground, but we were able to use a technical document that we did revamp with the Maryland Aviation Administration, and we relied on this very comprehensive technical report prepared by the State Aviation Administration. So it really was a joint effort. We worked with the sponsor, and we did the environmental process, and we actually did it very quickly because the state was very hot to get this facility started in time for the next Christmas season so that Amazon could develop all of its packages. So I think what you need to take away from this is that there are more of these lawsuits coming, and the FAA is not the real party in interest. You are. You're the real party in interest if you are building a cargo facility. Another one that we've seen is at the San Bernardino Airport, which of course is in your state. And we haven't been sued on this. I'm guessing that we will be sued by folks who are complaining about this. There's been a lot of press on the cargo facility. And this is a facility, proponents say this is going to add 3,800 jobs. It's going to increase $5 million in annual tax revenue. But the new facility could add 26 new cargo flights per day, or as many as 100 during the holiday season. And this may be another fire that the FAA has to fight, but like the cargo facility at BWI, as I said, the FAA is really not the party in interest. It's the sponsor who wants this property. So the airport authority and the FAA have to work closely together. And the key point here is that if you work for a sponsor, you've got to hire a top-notch environmental firm to help you with the CAT-X or with the environmental assessment. And you've got to work hand in glove with the environmental specialists at your local FAA Airports District Office. And you've got to do a well-documented environmental assessment. And you've got to take the same lessons learned that we talked about earlier and apply them in your situation, because if you don't, your risk when you get sued goes up. And like I said, we've tried to learn from the Phoenix case and apply the lessons learned. And my office has, as I said, gone around the country and has talked to the FAA people, the environmental specialists, and the people that work on these projects. And so you can tap into that resource by working closely with your environmental specialists and with the people in my office, the staff lawyers who are based all around the country that are airports and environmental law attorneys that will be working with the environmental specialists. All right, so any questions about the NEPA cases that I've talked about so far? Yes, sir.
Yeah, there's a conundrum here that bothers me a little bit. It's a chicken and the egg problem. You talk about citizens who are concerned about building a new facility and it generating traffic. Most every airport, even little airports, they may be old, but they have master plans and they project, forecast growth in traffic. And don't you at some point need to plan facilities to accommodate that growth in traffic versus generating traffic by building a facility? Do you understand my conundrum there? Which comes first, the chicken or the egg, in the minds of the public, and what's defensible in the court?
Well, as I said, NEPA is a procedural statute. And so really the challenge is, have you done the environmental process correctly? And if you've done it correctly, if you've done the consultation, if you've gone through the environmental assessment correctly, if you've done a purpose and need statement that's correct, if you've done everything correctly and thoroughly, in theory, the court should bless what you've done. But yes, there's no prohibition in the statute for growth. You just have to do the environmental process correctly. So the message that I have for you is that, A, either have somebody on staff who is well experienced and knows how to do this, or hire a top-notch consultant and work closely with the FAA staff. If you've got one of these projects, they certainly know how to do it. And but I often say to my staff, anybody can sue anybody else for anything. Now, does that mean that it's a good lawsuit? No. What you can do is you can reduce your risk when you get sued, because I'm telling you, we did a workshop for one of our projects. I won't tell you where it is. It was in California. And within the FAA, the video went viral because we had to shut it down. People were so ugly and acted so badly in this public workshop. And we literally, the people that were in charge looked at each other and they nodded their heads and they said, "We're done." And they closed it down because people were so angry and so upset and were acting badly at these public hearings. And so it is a problem, but I'm not sure I know what the solution is, because as I said earlier, it's a zero-sum game. If you move traffic, someone new is going to get the noise. The noise is not going to go away. And the FAA doesn't control how many flights there are. So if the economy is booming and Amazon is building facilities and people want to take their vacations in Bahamas and get their laundry detergent from Amazon, there are going to be more flights. And none of us control that. The airlines are they're going to do supply and demand. They're going to schedule as many flights as there are people who want to take them. And if if our economy is booming, then there are going to be lots of Amazon facilities at places like San Bernardino and BWI. And so, Mark?
Have a comment.
Yeah, I just want to put a little bit of perspective on, because I know San Bernardino. In fact, I'm meeting Monday with a coalition group, interesting coalition. It includes Teamsters, Sierra Club, Center for Economic Justice, and some warehouse group that I'd never even heard of, and then there's another party too. I can't remember who they are. And I think the thing that you have to understand, and this is something we deal with in California, and I'm speaking more to the California people, and what Jim said is exactly right. that there is a difference in terms of the thresholds used for CEQA versus NEPA. And what we find, despite how many times we say it, is we basically get, when we look for the EA, a CEQA document that has NEPA stamped on it. In essence, that's what it is.
Right.
Okay? And CEQA is programmatic. You have to disclose the worst case scenario, talk about it. You have opportunities to dismiss some options, items that you can't do under NEPA. So it looks at the whole world, and it looks at different thresholds than NEPA. NEPA is more project specific. So when we looked at something like San Bernardino, because we just finished that, we spent a lot of time just trying to understand the scope that we were studying under the environmental assessment. And it took more time than you would think to figure that out and get that disclosed, because as Jim said, in NEPA, we're not going to put something out there that we can't defend from a procedural standpoint. So if we don't understand it and can't articulate it clearly, how is the public going to understand it? And that's the type of thing they can catch us on. So that's what we're trying to avoid. So we got through that hurdle. After that, we had to look at the analysis, and the specific analysis we were asking was for the specific scope of work. And of course, we were getting stuff that was done under CEQA that wasn't specific to what we were studying. So we had to come back and work that out. Now, sometimes when we do that, it causes a CEQA problem, because you disclose to the world it's this, and now in NEPA we're saying it's that. So we have to figure out and build a bridge sometimes for that. Okay, so we went through that. How it's got tied up is that a lot of the interest, we knew noise was going to be an interest for the people in Lake Arrowhead. They haven't complained yet. I'm sure when they see a plane, they will. But it was properly disclosed. There was no new routes being built. So we knew there was going to be an issue, and we knew air quality would be an issue. And kind of what this morphed into was, although Amazon was not named, was people wanting working wages and using the NEPA process to try to force a community benefits agreement. So when that kind of thing happens, and we got about 500 people at the public hearing, we got about 900 comments. Got a few good ones, but we got a stack of book with comments for the EA about this high. The nice ones were like, "Thank you very much." These were the negative ones. And we had to kind of contort a little bit, because again, it's a disclosure process, and what we had to clearly describe is the contributory impacts for the scope that was being studied. So that we can make it real clear that, yeah, there's some cumulative things that may be happening outside the scope that are not necessarily contributory to this project for the time frame, for the facilities that are being proposed here. So if that makes sense to you, that's kind of what the challenge is. So kind of getting back to the question about growth versus no growth, there's nothing wrong with that, but just understand that I can't stress the importance enough about making sure that the consultants, environmental consultants, understand NEPA and understand the difference between NEPA and CEQA. Because again, at the end of the day, despite all the pushes and rushes and interest that people had to get this thing built, the EA done rather, we're not going to put something on the street we can't defend, knowing that it's going to probably get challenged. And I would expect it will get challenged. I expect this group to be with us next week to fish around and figure out what they can sue on. Of course, we're not going to tell them anything, but I guess that's by context, I guess, on the ground level, to kind of what Jim was saying. There's nothing wrong. I think we want to support the growth, but it's a matter of disclosure and just making sure that the stuff kind of line up. The other thing, too, and just one more quick thing. We spent a lot of time looking on the website for the sponsor. And, again, on the CEQA, they talk about the grandiose things they're doing, and there's all kind of documentations on the website. But, yet we're looking at something more scaled down. So part of it was just how do you bridge that gap so the public doesn't say you're lying, FAA, under NEPA. This is what they're going to do. They talked about it in the CEQA. It's even on the website. So those are the type of considerations I think we have to work through, particularly in California. So anyway, that's my 2 cents.
Thank you, Mark.
Valuable, yeah. Jim? Oh, Mark, use your command voice. Yeah.
I don't want to jump the gun on maybe some of the other sessions that are coming up, but I just wondered if you see more lawsuits in the future as we get into VTOL, air taxi, but especially the idea of some companies using pilotless vehicles or aircraft to deliver packages. Do you see more lawsuits occurring as a result of that, as those may be located on a new airport?
We're hiring more attorneys.
Good answer. Okay, go ahead.
All right.
Thanks,
So-
Mark.
All right, so let's move on to aviation fuel taxes, which we've already heard talked about a little bit this morning. I don't want to spend too much time on this, especially if you are well aware of it. I know that that the Airports Council is really interested in this. In fact, we just got your letter, Sarah. I have it in my briefcase. So, for those of you who don't know, the FAA was made aware in 2014 that there was a widespread problem of aviation fuel taxes not being spent on airports. And so in 2014, the FAA published this policy, which basically says you got to use aviation fuel taxes on airports. So we have, you know, it's a long process, but in 2014, basically, we said, okay, we understand now that we know the scope of the problem that a lot of non-sponsor folks out there, either local or state agencies that were taxing aviation fuel, were not spending it on aircraft, airports. And so we said, okay, we understand that this is a problem and that you're going to have a shortfall in money. So, for example, Clayton County, Georgia, which we're going to get to in just a couple of minutes, was right next to the Atlanta Hartsfield Airport, and part of the airport was in Clayton County. But Clayton County didn't own or operate the airport, but was taxing aviation fuel and was spending it on everything from schools to police stations. And they acknowledged this. And of course it was a problem all of a sudden because they were getting millions of dollars in aviation fuel taxes that they were happily spending on something other than airports. And so what the FAA says was, okay, we get it. There's going to be a shortfall. You got to figure this out. We're going to give you a grace period, a 3-year grace period, and if you publish an action plan by December the 8th, 2015, then we're going to give you until December the 8th of 2017 to come into compliance. Well, of course, that date has come and gone, and there are many municipalities, many right here in California, that are not in compliance. And so the FAA's Office of Airport Compliance, aptly named, has reviewed 184 of these compliance plans from states and local governments who are non-sponsor taxers, and about half are compliant with the policy. And so our Airports Compliance Office is, let's say, they're following up with all of those municipalities that are still not in compliance, and we're working with them at this point to get them into compliance. And so we need your help, though, in educating the non-sponsor localities that are still taxing aviation fuel and are not spending it where they should be spending it. And so yes, it's a huge problem. We're on it. We're working on it. And certainly we can assess civil penalties under our statute, or we can apply to a U.S. District Court for a compliance order. And in one instance, we've done that, and that is the Clayton County case. Actually, we didn't ask for the compliance order. Clayton County sued us. And here's how that happened. So what happened was Clayton County, as I said, is a county just west of the airport, and part of the airport, the Atlanta airport, is in Clayton County, and for years they'd been taxing aviation fuel and spending it on good projects, good things like schools and police stations, but they became aware. They did file an action plan on time, but then they changed their minds. And they said, we think you're wrong. We think that we are entitled to spend this money the way that we're spending it. And they wrote our chief counsel and basically took issue with the policy that we put on the screen a few minutes ago. And our chief counsel, Reggie Govan, at the time, wrote back, and he basically wrote a letter disagreeing with Clayton County and restating the 2014 policy. Well, Clayton County then sued the FAA in federal court in Atlanta in the 11th Circuit and said that the chief counsel's letter was final agency action, even though the letter expressly said it wasn't. And so we went to court, and the 11th Circuit agreed with us that the letter actually was not final agency action. We actually hadn't threatened them with a compliance order or with civil penalties. But I think if we look at that decision, it does provide some handwriting on the wall, because basically what the court said, without expressly approving the FAA's position in the litigation, the 11th Circuit cited the statutory language from the revenue restriction statutes that prohibits aviation fuel taxes from being used for anything other than aviation. And the court cited the 2014 FAA policy, interpreted the statute and the grace period that the FAA had extended localities to come into compliance. And it was clear, without going as far on the merits, the court basically said the statute was clear and the FAA policy was clear, and it cited the fact that the FAA had been working with local governments to overcome any hardship. Clearly the message was on the board, the handwriting was on the wall, and they basically sent the message to the county to go figure this out, which they did. They have come in and have worked things out with us, at least at the Atlanta airport. So the FAA in California has requested the state provide a detailed and specific plan for tracking and reporting aviation fuel tax proceeds per jurisdiction to permit local jurisdictions to comply with federal law. So as I said, I think that probably most of us in this room are pretty much in agreement on the implementation of the policy, and we're certainly on it. And it's as much a resource problem as anything, because there still are many localities, as there are here in California, that haven't come into compliance. But I will tell you that the Associate Administrator, Kirk Schaefer, is very aggressive on this and is basically directing his office and our office to go out and put this right. Okay, so now I'm going to shift to another case where expenditures did in fact qualify as operating costs, permissible operating costs at an airport, and this is the Port of Portland Stormwater case. So this is something that I want to relate back to the discussion in the last hour when we get to this. And so basically this is a case that was filed by A4A, and in 2016 A4A filed what's called a Part 16 complaint, which is an administrative complaint alleging revenue diversion at the Portland International Airport that's operated by the Port of Portland. And basically what A4A alleged was that the airport was paying its utility bill using airport revenue to pay a combined sewer, stormwater, and Superfund bill that all the localities that had property in the city of Portland were paying. And what A4A asserted was that this basically was revenue diversion, that the costs are not incurred on the airport's behalf and do not directly benefit the airport. They filed this Part 16 action, and so we have a two-step administrative process. It first goes to Kevin Willis, who is the Director of Airports Compliance, and he agreed with the Port of Portland that these were permissible costs, that it was not revenue diversion. and then it went to the associate administrator for a final agency decision. And again, the associate administrator agreed that the port's payment for these fees was permissible, that this was an operating cost, and that it was not revenue diversion under the revenue use policy that we saw earlier or the revenue restriction statutes. A4A then sued us in the Ninth Circuit, in the DC Circuit. We can get sued in the DC Circuit because the FAA, of course, is in DC, or we can get sued wherever the facility is. And in this case, the A4A decided to sue us in the DC Circuit. And the court found that, in fact, these costs were permissible. It found that Congress expressly authorized the use of airport revenues for operating costs of the airport, and that the FAA had properly determined that these general expenses of a utility were in fact operating costs. So basically what the court said was that I think implicit in this decision was that the FAA can't go around the country and look at everybody's utility bills and see if they're including permissible costs. But they did look at these utility costs, and they said, yeah, this is a fair allocation of how to allocate these. But I think one of the reasons I wanted to bring it to your attention was it relates back to the PFAS discussion. Part of the utility cost was there was a cost for a Superfund site into the Willamette River. So part of the stormwater had contaminated substances, hazardous substances that were going into the Willamette River. And the utility bill for everybody in the city of Portland was including these cleanup costs for Superfund. And the court said, that's fine. That reflects value of services and facilities provided to the airport indirectly. And so the message is that these are operating costs. They may not be direct operating costs, but they're indirect costs. And the thing that I think is interesting about this is that if you're in a situation for PFAS or for any other contaminant and you're billed for these either through Superfund or through some other liability scheme, you may be entitled to use airport revenue to pay for these cleanup costs per this DC Circuit decision. And so this is something you want to be aware of, and know that operating costs can sometimes include things that you might not at first blush think that they could include, and can include things that are indirect cost, and they don't have to be just direct costs that you might always think of as aviation services. Any questions about that case?
Well, not about that case, but just what you said earlier. When you said non-sponsor, are you talking like an airport like ours in Monterey, where we're a special district, a standalone entity? The money that's being generated in taxes now go to the county and state. And the remedy, if they're out of compliance, would be, I assume, the loss of AIP or other federal funds. But they don't care about that because it doesn't affect them at all. How would that be addressed if you look for a remedy?
Well, the remedy could be either a compliance order, it could be civil penalties.
Directed at the county and not at the airport?
Well, it would be directed toward the non-sponsor who doesn't own and operate the airport, that is spending aviation fuel taxes on something other than aviation.
What are you going to do?
Soon. Okay. Let's see how I'm doing on time here. Okay, I've got about 15 minutes. We're going to cover the FAA Reauthorization Act, Section 163, which is very complicated, and I'll tell you, my staff is nervous about me talking about this because they know way more about it than I do, number one. And number two, we haven't quite got our arms around it. My staff meets every week with the airport's program office. They have a standing meeting every week to talk about this. So this is something that's very front brain for the FAA and is something that we are still struggling with, but I've got a couple of examples that we can talk about when we get to the end. But basically, what Section 163 of the FAA Reauthorization Act said was that, unlike in the past, the FAA is now limited on the things that we can regulate at airports. So this section involves the limitation of non-federally sponsored property at airports. And it's basically broken down into 4 different sections. Section 163A, which is the big general prohibition about FAA regulating airport property. And then the Congress took it back a little bit in the exceptions, and then there's a rule of construction. And then 163D is really totally separate. It's about the limitation of approvals that the FAA has for airport layout plans. So we're going to spend 5 minutes on each section. So the prohibition is in Section 163A, and it basically says that the FAA can't either directly or indirectly regulate these 3 things: the acquisition, use, lease, encumbrance, transfer, or disposal of land by an airport owner or operator, any facility on the land, or any portion of that land. Wow, that is so broad. It basically, if you just looked at this, you would think that the FAA has no regulatory authority on airports anymore. Well, Congress took a lot of it back. So in the next section, it says that FAA, in fact, may regulate to ensure what the things are that you would expect the FAA to regulate. And those include, first of all, the safe and efficient operation of aircraft or safety of people or property on the ground. That's our mission. The FAA's mission is safety of aircraft, safety of aviation, and of course, the new statute doesn't apply to that. The second thing, though, that it regulates is that Congress still wanted to make sure that the airport owner, the airport sponsor, was still either paying or receiving fair market value for the sale of property. So if you're engaged in sale of property, you do need to check with us. You need to check with your local office and get a pass to make sure, and you need to document it so that there is fair market value for any transaction of property. And then thirdly, the land or acquisition that is used, if there was federal funding that was used, or if there was Surplus Property Act property or passenger facility charges that were used to acquire property, the FAA still regulates those. So if you use federal money to acquire property, it's still regulated by the FAA. All right, so let's look at Section 163C, which is the section that basically says, we talked about 2 instances of revenue diversion with aviation fuel taxes and then the Portland Stormwater case. The Congress just made it very clear that the revenue use statutes are still in play. We're still regulating revenue diversion at airports, and that's really all that section says. And so finally, Section 163D, which may be the most complex of any of the sections, is, as I said, it's really completely different than the other sections. And this has to do with your airport layout plans. And it basically says that the FAA only has limited authority now to approve changes to your ALP. So the statute, 47107A16, was amended to say that the FAA will review and approve or disapprove only those portions of an airport layout plan. First of all, we think of these as 3 different zones of interest. And the first zone of interest is one that materially impacts, again, the safe and efficient operation of aircraft. There's our mission, the safe and efficient operation of aircraft at, to, or from the airport. And then secondly, that would adversely affect the safety of people or property on the ground. Again, part of our mission, adjacent to the airport, as well as a result of aircraft operations. And then finally, the third zone of interest is that it will adversely affect the value of prior federal investments to a significant extent. Well, what the heck does that mean? Well, we sure haven't quite figured out yet what that last part means. As I said, we're meeting weekly to develop policy that is going to be issued both internally and externally. But right now, we're basically handling instances both for 163A and 163D on an ad hoc basis. And the message that I had for you is that you really do need to still check with us to allow the FAA to tell you, especially for an airport layout plan, whether or not we're going to want to weigh in, whether it's in one of these 3 zones of interest. What happens if you don't check with us and you don't get FAA approval and you make a change to the ALP and then the agency determines that the alteration to the airport layout plan adversely affects the safety, utility, efficiency of aircraft operations or of any property on or off the airport, or that it adversely affects the value of a prior investment, federal investment, to a significant extent. Well, there are consequences. The statute has been amended to say that if you do that, if you amend your ALP and you don't seek our approval and we disagree that you're in one of these 3 zones of interest, then first of all, we can ask you to eliminate the adverse effect in a way that we approve. And there's no qualification in the statute. In section 47107A16D, it just says we can ask you to eliminate the adverse effect in a way that the agency approves. Number 2, we can ask you to bear all costs of relocating property to an acceptable site. And third, we can even ask you to restore the property or its replacement to a level of safety, utility, efficiency, and cost of operation that existed before the alteration was made. So the bottom line is be safe rather than sorry. You need to check with your local office, your local FAA office, before you make an ALP change, and get it in writing from the office, so that when you make that change, when you put that Kmart out in the back 40, maybe Kmart's not open anymore, Walmart. Put the Walmart in the back 40 that we agree. So I do have 3 examples, and I think I can do those in the next 5 minutes. The first is what was affectionately known as the Stewardess College, the American Airlines Flight Training Academy at DFW. And if you see on the left there, the left photo is an aerial photograph. Encircled in red was the Stewardess College, and the photograph on the right is a close-up of the front of the building. Well, this building was an old building. The Texas Historical Commission believed that it may be eligible to be listed on the National Register of Historic Places. The buildings were located on airport property. And then finally, an EA had been started. There was a draft EA that had been done and FAA was involved in collaborating with the airport and with American Airlines on this, and it was ready for public comment. And then 2018 came, and the FAA reauthorization was passed, and we started looking at Section 163D, and so we came up with, of course, these three questions. Does the project meet any of the following? Did it materially impact the safe and efficient operation of the aircraft at or to the airport? The answer was no. The second question, did it adversely affect the safety of people or property on the ground adjacent to the airport? The answer was no. Finally, did it adversely affect the value of prior federal investments to a significant extent? Well, this hadn't been bought with federal money, and the answer was no. And so the conclusion was there's no federal action. We don't need to do an environmental assessment, and the section consultation was terminated, and the project went forward with our blessing without an EA being done. And basically, this was one of the projects that we have agreed with the airport and the airlines that 163 basically has us step out of the process. And so we weren't, after actually literally midway through this project, through the environmental assessment, it was stopped. We did the Section 163D assessment and determined that there was no federal action, and the project was allowed to go forward without our involvement. The second project is one in Ohio at the Fayette County Airport, and this involved a children's home, a very old children's home that was deeded to the county in 1864. The building was constructed in 1886. It had been vacant since 2010, and even though it was on airport property, as you can see from the red circle there, it's far from the buildings and from the runway at this airport, and it wasn't expected to be used for aeronautical purposes. So we went through the same questions. Did it materially impact the safe and efficient operation of aircraft? The answer was no. Did it adversely affect the safety of people or property on the ground? And the answer was no. And then finally, did it adversely affect the value of prior federal investments to a significant extent? Again, the answer was no. And the conclusion was this project can go forward without our involvement because there is no federal action. And that is completely different than it was before this statute was passed. Before the statute was passed, we would have been actively involved in doing an environmental assessment, and the project would have gone much slower. So those are two examples that my staff allowed me to cite to you, and with nervous folks back in Washington say, don't say anything else. Having said that, let's take questions. Yes.
Soon, because like right now, it's quicker to get the CADX approved than to go through the Section 163 determination process.
Are you asking me?
Did
or are you
everybody
telling?
hear that? Did Judy? Yeah, here, Judy.
So I'm asking, I was asking if these determinations will be able to be made by the local EPS soon so that they don't have to kick it clear to your ad hoc committee for a determination.
Right now, they do have to go through the ad hoc committee,
Right.
but they're handling these pretty quickly. As I said, they meet weekly, so it's a high priority for us. It's a joint group between the technical people in the airport's office and people in my staff, and they've spent hundreds of hours looking at the statute and looking at examples and thinking of all the nuances. So especially for the easy cases, like the two examples that I've cited, we're turning around those pretty darn quickly. The airport district offices are coordinating because we want to be consistent we want to have the same answer for everybody. And so this is getting a lot of attention at the local level, but they are going through this one, they call it a 163 committee.
Yes.
So you mentioned surplus property, and I have to ask one question to kind of lead into the next. So the farm bill, as it applies to hemp growth on airports, is that allowed if it's a U.S., it's a federal bill?
I'm not even sure I understand your
So growing hemp and not cannabis, but hemp on airport, is that allowed? And the reason why I'm asking that is, what if the property is surplus? Is that still obligated, even if the airport still owns the property? Is there an obligation that exists?
I'm not following the question.
So
This is a 163 question.
Well, I'll probably talk to you offline about about some surplus property and use and environmental. So
Okay.
I'll just talk to you offline. Yeah.
And that's a session.
Yeah, it is.
Okay.
Yeah.
Well, I do think
Put
I'm
the-
out of time.
put that in the notes.
So I want to stop and give Mark his full 29
Right.
minutes.
Right. Yes. Yes. Yeah.
Thank you very much.
Jim, thank you so much. I do realize maybe the first time in history I put entertaining speaker and FAA in the same, but it was fantastic, and I know attorneys really enjoyed. So it was excellent, really. Thank you. So if you want to stand up and stretch just for a minute while Mark comes up, understand. We've got just another about 30 minutes or so, and then we'll go into buffet lunch. So hang in there. Appreciate it. Mark, as most or all of you know, is Director of Airports for Western Pacific Region FAA, and so happy to have you with us today. Why don't we give him just a minute or two? I didn't mean to...
I'm just trying to turn it off so I don't keep making noise. Okay.
Right. Yeah. Okie dokie. That was a short minute, right? But at least, okay. All righty, Carol, we're gonna just move right into Mark. So, with that, I hand it over to Mark. I don't know if you are you guys set? Okay, great. Thank you. Here we go.
I stopped using slides. That way I can deny everything I tell you.
Go. These presentations, I will remind you, Jim's, for example, will be on the swahi.org website